Okay, we're going live.
Cool.
Welcome to our first business board. Oh no, it's not our first. It's our second business broadcast of 2022. It's my first business broadcast of the year with a guest, however. So I'd really like to welcome today Richard Devall. Welcome, Richard.
Hello there. Happy New Year to you.
Yeah, Happy New Year indeed.
I know it's a bit late in the day.
Well, yeah, it's a month today. It's Valentine's Day.
Yeah.
So yeah, the year is going to be flying by. So Richard's joining me today. He's Head of Employment and Immigration at IBB Law, which is perfect for what we're going to be talking about today. But just a bit of housekeeping. As always, please do post your questions and comments in the chat. If you're watching live, if you're not watching live, you still can put your questions and we will try and pick them up later, but obviously not during the live broadcast. So please do say hello to it so that I know that this LinkedIn Live is actually working. The technology is doing its job today. And very lovely for you to join us. Hopefully you're all settled in with your sandwiches and your cup of tea. So what we are going to be talking about today, just for half an hour. So as you know, we try and cram as much information as we can into our 30 minutes. But we are going to be talking about international home working. So what does that mean? So we are going to be talking about if an employee comes to you and says, right, well, we're remote working now, but I want to work from Italy. What do you do? Or what are all those implications? And that's where Richard is our super duper expert and is going to be able to answer those questions. So are you ready? Ready, Richard?
I think so. Let's go for it.
And ready for the deluge of questions that we'll get as we go along. So, be ready to tackle anything. Okay, so just first of all, thinking about the employment implications. So what employment rights does an employee have if they end up working overseas?
Very much depends on the actual factual position of that particular employee. I think it's probably worth just saying that why this has come about, I think, is because of the pandemic and Brexit. And there's been so many people who've been in different locations than they were before. They may have gone back to their home countries, got stuck there, and that's what I think has driven where we are today. And we're seeing a number of countries who are having a lot of these requests from people who want to go and work on the beach or in their home countries or be near their relatives. All sorts of things going on. But on the employment rights, the reality is if someone goes and works in another jurisdiction, there's every chance that they're going to have employment rights in that jurisdiction, as well as potentially employment rights in the UK. Now, those employment rights, depending on where it is, might be far more beneficial, perhaps, than those in the UK. So there might be enhanced maternity pay we don't get here, or sick pay, or holiday pay. So all those things need to be taken into account. There are sort of a number of, from an EU point of view, you've got mandatory rights that may allow an employee to have the best of both worlds if they go and live in France, for instance. So they could say, right, the French employment rights are much better than the UK ones. I'm going to pick those and bring my claim there around discrimination or something like that. So it's something very much you need to be looking at.
Absolutely. And we've already had our first request. So Guy, he's asking, have I told you I want to work for the Cayman Islands? Well, Guy, no, you haven't. That's news to me. And we definitely know there's lots of purposely positive tax things working in the Cayman Islands. So well, let's talk later. Interesting. So if they go and you do manage to work this out that they can do this, do they retain their UK employment rights?
Potentially, yes. Again, it would depend on the sort of actual circumstances of that individual, but there are the sort of rights and liabilities with employment contracts, and you need to look at actually what are the terms of that individual's employment relationship, particularly around restrictions, perhaps. So you may have someone who's subject to restricted covenants or clauses around protecting your confidential information, and you need to be very careful, I think, that when someone changes their circumstances to goes to live in Spain, do those restrictions that you may benefit from here, do they actually work in Spain? Because it's local laws may apply for the enforceability of those restrictions, and you may need to think about changing them or reassessing them. And that goes for any number of policies you may have around performance management, perhaps, or IT usage. All of those considerations need to be looked at. Do they actually work? They may work in the UK, but they won't necessarily work in Switzerland or France or the US or wherever it may be. But yes, you are basically giving someone the ability to decide perhaps which jurisdiction, which laws they prefer to work under.
So does that mean that you'd potentially have to have a local employment contract under the jurisdiction law that the country that they're in?
That may make sense. Not necessarily. I think it probably depends on what is happening. How long is that person likely to be there? If it's permanent or for the very long term, then yeah, I think probably serious consideration should be given to perhaps putting in place a local contract. If it's a secondment type arrangement, so more temporary, then perhaps not, because that would typically work. You'd have a UK contract with a secondment letter, which then sets out the basis upon which they'll come back to the UK. So I think it depends on very much on the length of that, what we anticipate, how long that person's going to be away, and is it for the long term. But it's worth noting
really have to look at the individual circumstances
absolutely.
and the location.
Absolutely, yeah. It's worth noting that there are some, particularly European jurisdictions, that actually require an employment contract to be in the local language, in their language. And actually, if it isn't,
what, like Wales?
No comment. It's void, so that's an important consideration. Yeah. You can get around that by having a dual language contract, but it's sure. you do need to watch it.
Okay. Understand. Which neatly goes into the immigration implications. So, what else do we need to think about from an immigration perspective, where the person's going to work in a different country?
So I think the first thing is, and the most important thing is to make sure actually that you as an individual or the company is satisfied that that individual can go and work where they're going to be living and working. Now, clearly, if they're going back to their home country, that's fine. But if you are going to the Cayman Islands, it might be that, probably you will need some form of visa or ability to actually work there. Now, there are visitor visas typically around the world. We have them here. They allow a certain amount of work, but it's very low key and it really doesn't cover productive work.
Yeah.
So you can't rely on a visitor visa. So you're looking at working type visas. So yeah, just going there, maybe on a visitor visa, sitting down and working, there is every chance you will be breaking immigration rules in that particular jurisdiction.
Indeed, and you've got to be very careful about visa requirements, as a certain tennis player is having at the moment. You don't want to end up in a legal battle, whether it's valid or not.
And also, if it all goes wrong and they are questioned by the individual has a problem with the immigration authorities, of course that has a knock-on effect on the business, reputationally, and also you may not be able to bring anyone else into that country in the future because you've got a black mark against your name.
Yes, you've got to be very careful, very careful. Yeah. So just thinking about it, I mean, obviously it's sort of different if you're going to, actually go and work there for a period of time. But will that count? I'm just thinking, does that count like if you're going for, say, an exhibition or something like that, or a sales meeting and a meeting? So
not necessarily.
You've got to be very careful then.
You've certainly got to be careful, but it doesn't necessarily require you to have anything beyond a visitor visa or some sort of business visa, which we have sort of here in the UK, and most countries will have some equivalent of. But as I say, yeah, attending a conference or something, typically you'd be able to do that under a business visitor visa around the world. But it's when if you're talking about someone actually going to home work or work in that country, and they're going to do productive work for a long period of time, they won't work those sort of visas.
No, definitely need your proper business work visa then. Okay, great. So if you actually decide that, this is something that we're potentially going to consider, the delightful risk assessments. It's always delightful in HR and employment sphere, full of them we need to do. So what sort of risk assessment would an employer have to be thinking about if they're going to be working overseas?
The key one is health and safety. An employer has got a duty to take all steps that are reasonable, really, to protect the welfare of their employees, and that would extend to employees who are working overseas for you. So you need to be very careful that you have carried out an assessment as to whether there's an increased or a different health and safety risk wherever they may be going. And also, there will be a different health and safety regime in a different country, and it might be that there are more onerous health and safety requirements there. There might be less, but you need to think about and have a look at actually what are our obligations. The key, I think, is to carry out an assessment as to what that individual is going to be doing, where they're going to be working, so you can assess for yourselves what if any risk there is, and how you might deal with or mitigate that risk in the way.
Indeed.
I think the other point is insurance, and I've seen some very sad examples where people have moved their place of work to another country, and they've died or something tragic has happened, and the insurance cover that their employer provides, death in service, medical cover, insurance, doesn't work because the insurer wasn't aware that they were working from an overseas location. So if you are moving people around or people are changing their place of work, really important you check your insurance policies to ensure that those people are covered by your insurance policies in place.
Okay, we've got a couple of questions come through, so I think it's a good time to cover those. And please do any other questions that are coming up. Please do, if that you're thinking of it whilst watching, please do write them down. There's no such thing as a silly question. Though there is such thing as a silly comment always. Let's see, what's Guy doing? He's already packed his suitcase with a load of wine, right, to go off to the Caymans. Thanks, Guy. You are going off to work in the Caymans, I thought. But anyway, right. But a sensible question from Liz. Here we go. So from saying, if an employee has EU citizen is an EU citizen with settled status in the UK, how long could they leave the UK before losing their settled status?
It's currently, you can be out of the UK for up to about 5 years for a settled status. If someone's got pre-settled status, it's typically 2 years. There are some exceptions around that, but yeah, it's 5 years normally for settled, 2 years for pre-settled.
Okay, so you need to make sure that you're not. It's not going to cause you problems in the long term. Think about what your longer term plan is as well to make sure that doesn't mess everything up.
Yeah, and just taking that slightly wider, where you might be sponsoring people in the UK, be they from the UK, from the EU, or wherever in the world, but when someone leaves the UK for a period of time, and they are subject to visa requirements in the UK already and have rights to be here, they have the potential of losing those when they leave, of course. So it's, as we just talked about on the settled, pre-settled, it's just having that awareness of, well, if you're sponsoring someone and they leave, you can no longer sponsor them. If they're going to be away for some time. Obviously going on holiday is fine, but there are wider considerations that can have quite serious effects for people if their intention is to come back to the UK and live here permanently in the future. leaving it for a period of time might damage that, and they have to start again.
Yeah. So you've really got to think about it carefully.
Yeah.
I've got which this segues really nicely into our next section from Guy. Could risks include protecting clients' data and tax issues? And trust me, he does not know the running order, but that is our next area. So let's go into there. What sort of things do we need to be considering regarding data protection?
There is potentially a whole host of data protection issues that come up. And actually, they come regardless of whether someone's working overseas or working from home in the UK. I think they equally apply, but perhaps more so if they are going to a different jurisdiction. The key is to have appropriate safeguards in place with your data protection policies and your privacy notices and your procedures. But someone working from home, you need to be thinking about, well, what is their Wi-Fi position? Are they more open to cyber fraud or hacking than perhaps they otherwise would be? And it does present, I think, a whole load of security challenges around data. Again, it will depend on that particular individual. To what extent are they involved with data or the transfer of data? And it may be they really have nothing to do with data, in which case you can be more comfortable with it. But if they are heavily involved with data transfer, then you need to make sure your policies and processes are robust enough to cover that fundamental change in where someone's working.
Yeah, absolutely. And I'm just thinking, just because we have to obviously do a lot of work on anti-money laundering, and if somebody went and worked in one of the blacklisted countries, that could have a complete change to our AML policy and different issues.
Most certainly.
Yeah.
Yeah.
So, but something else that just was occurring to me. So saying somebody comes along, say Olivia comes and tells me, oh yes, right, I want to go. I'm working from home, but I want to travel for 6 months. And across Europe, for example, but I'm going to be working for you at the same time at multiple locations. One, what sort of different issues does that occur? And secondly, are you then setting a precedent? Does that mean that every time somebody comes to you with this sort of answer, that because you've already done it once, you're pressured to have to say yes again to the scenario for somebody traveling or working from their French villa?
Yeah, I mean, there's sort of multiple location question. That's an interesting one.
Sorry, bit of curveball.
No, it's a good one. I like it. I suppose it depends on how long they're going to be. If they're going to pop in for a couple of days and do a bit of work on their laptop and then go to the next country, probably that's all right in a sense of whether or not you have a great risk in that particular country that they're working in. If they're going to spend 6 months in their country and then move to the next one, that may change things significantly. So we're back to that. You need to look at what's going on the ground and assess it, really. Your second question around customer practice and does it set a precedent? Yeah, potentially it will. If I suspect when a lot of people make a request, if they are going to make a request to go and work somewhere, it typically, I would imagine, would be around because they want to be nearer their family or their relatives, or just want to go back to their home country, but they want to carry on working.
Their son.
Yeah, exactly, working with somebody's son. And so there will be a sort of an emotional undercurrent, really, to the request. So that, for me, the key is to make sure you've thought about it. You've got something in place that is where you've set out and everyone's is transparent and clear as to how you will approach someone's request to work from home overseas or to work from overseas, and if you are minded to look at those requests, then everyone understands what the eligibility criteria would be for being granted it, because clearly it won't work for everybody, and it may be that those criteria would be based on someone's position or how long they've been with the company or what they do, the country they're going to, their home working setup. All of those things perhaps are criteria that everyone is clear on. If they make a request, these are the criteria that the business will look at. And hopefully everyone will then think it's fair and consistent and transparent as to whether or not they are given their request. It's quite possible other companies may say, do you know what, we're not going to entertain anyone working from overseas, from home or otherwise, and that's just the end of it. We're just not going to do it. And I have seen clients do that. Equally, I'm seeing a lot of clients who are being more open-minded about it and happy to look at it on a case-by-case basis. And they are working on policies and have policies now as to how they might approach it. It's just making sure everyone knows the playing field that they're going to, really.
Indeed. Okay, so we've been through all those different areas we need to look at. So so tomorrow, well, not tomorrow, on Monday, I have Jenny come to me and ask me that can she go and work in France for 6 months, because that's where her parents have retired to, and she wants to help look after them plus work still. What are my practical next steps? What should, as an employer, should we do next?
I would like to think that there is a process that is already in play, and we can take, it was Jenny, wasn't it? We can say to Jenny, let go and great, but if you can just explain why you want to do it and what you'd like to do, and perhaps there's a list of questions that revolve around how you will address the request. It's back to that eligibility criteria that I've been talking about, really. And then it's just a question of going through with Jenny about whether or not it works and getting to the bottom of what she's going to be doing and why she wants to do it, to a point. And then explaining to her, if it's a no, obviously explaining to her what the reasons for that are. And if it's a yes, what the parameters of that might be, and what would be expected from her. I would also suggest that if you are minded to agree to a request like that, that it's documented. So we get Jenny to sign up to probably some sort of template written agreement where it's clear what she made the request, what she'd like to go and do, what we've agreed that she can go and do. And it would be good if in that sort of agreement to give yourselves as much flexibility as possible to perhaps say there are certain situations where we may require you to come back to the UK. So everyone's again clear at the outset.
Absolutely.
As to, look, this may be permanent, it may not be, but we might actually require you to come back.
Yeah. If they've got to come back for a specific client meeting or presentation or something. Contrary to that, if we said no, what then happens? What rights do the employee have? Can they? Is there a formal appeal procedure, or does it depend on what procedure you've put in place? Is there, I don't want to throw words around, but is it they say, well, that's constructive dismissal then because you're not letting me be able to work in my place where I want to be able to work from, or unfair, or whatever else? Is that what
I think
we have to think there?
I think it'd be quite difficult for an employee to run a sort of constructive dismissal type argument on the back of it, but it really comes back down to the importance of having a policy and a process that people understand and following it and being clear about it. You probably would build in some sort of right of appeal to the decision. That would be, I think, a sensible thing to do. But bottom line is, if you've got someone here who's working on an UK employment contract, their place of work is the office, for instance, in the UK, then it's they haven't got an absolute right just to say I want to go and work in Germany or the Cayman Islands. Using that earlier example, so I think they would struggle to bring a legal claim around it. Perhaps the more important point might be talent and keeping your talent and not losing your talent. And we are in a global talent pool now across pretty much all service lines. And I think business is trying to attract as many people as they can to their businesses because it's incredibly competitive. So you run the risk, I suppose, that you lose one of your stars.
Indeed. Another thing I was thinking of is, so because as we know, remote working is now becoming more commonplace, or flexible working where people are doing more, 3 days in the office, 2 days at home, or some other similar arrangement. Where that is coming, is that so, should be employers be looking at, they need to be adjusting their contracts to update those scenarios, or is it sufficient because they, still have their contracts in place? So once all eventually the pandemic goes and you stop having the work from home guidance, that you just can flick back into normal practice. What are you seeing? Are people updating their contracts?
Yeah, that's a really interesting question. Yes, in part we are. So we've had this position where through government regulation we haven't been able to go into the office largely for many people, and so we've been working from home, and that is largely a temporary arrangement, although it's been going on for a couple of years for some of us.
So when does it become not temporary?
Well, I think right now, or certainly up until recently, because of the government guidance and regulations, I think it would be difficult to argue that there's been a permanent change, as it were. But when you start introducing hybrid type working, then how you document it and how you present that could have a bearing on whether someone could say in the future, well, this has now been agreed, this is now set in stone. I'm now going to do, for argument's sake, 3 days at home, 2 days in the office. And that is now the deal. Now, what you've done there is change the place of work, essentially. So customer practice can come into this. I do think it's sensible to document. If you are, as a business, thinking long-term and permanently, we are now going to have a hybrid working system, that should be documented, I think. If actually you're in that space, and I think a lot of businesses still, we are temporarily and for the time being having this hybrid working, and we'll reassess it in 6 months' time or 1 year's time, then again, I think that should be made clear.
Yeah, there's so Guy's made a comment which triggers another question for me. He's saying, for me, where we often need a second set of eyes to double check complex work, I'd be concerned managing and checking their work communication and trust would be key. Now, so obviously some people are managing that perfectly fine remotely, but in instances there aren't. So if you agreed to say yes, is it possible for you to say, yes, I agree to you working from France for 6 months or 6 months of the year, for example? How can you caveat it and say, however, if I find it's not working for whatever reason, that you can revoke it, this situation?
Absolutely. And that comes back to this suggestion that you document and have an agreement with that individual written down as to the basis upon which you're agreeing for them to go into work in France. And you can say within that, it's subject to this working. You could even say, look, we'll review it in 3 months' time or 6 months' time and see whether it's working. And if it's not, at our discretion, we will require you to come home or come back to the UK.
Indeed. Well, that's been absolutely fantastic, Richard. So, anybody that needs to get hold of you because they, they're watching it on catch up, or they were just too shy, or we've just run out of time for questions. Any more questions? Where's the best place for them to contact you?
Well, I'm at IBB Law. I think behind me there's a telephone number. I mean,
Oh, yes,
Nikki,
indeed. Yes, just
it's,
pause your screen, and there's the telephone number.
there is a
Perfect.
telephone number. Equally, Nikki, I mean, you've got my email address, and I'm more happy to share my email address, phone number, my personal phone number with everyone.
Excellent.
Is that the way of putting it? I don't know.
Yeah,
But
no, and obviously you're linked on for the LinkedIn thing. It's got your contact from
yeah,
LinkedIn, so you can just click on LinkedIn as well. So,
brilliant.
yeah,
And if you've
lots
got
of
any
different ways
questions,
to get
delighted to
hold.
help.
Brilliant. Thank you so much. Been really, really interesting. Lots of good information there. And as with so many of these other things that we go through, planning is the key. Get your procedures and your policies in place beforehand, so then you're ready for any requests from your staff. But that was really good. Thank you so much. I hope you have a lovely, lovely weekend. For everyone that wants to, please do join us next week, same time, same place, 12:30 Fridays. We will be next week. I will not be in the hot seat. It's going to be Guy in the hot seat, and it's almost going to be a rerun. If those of you that are regular watchers, we had Cal from Yes Tax talking to us about capital allowances, and in particular property capital allowances as well. There was terrible LinkedIn issues that day, completely out of our control. It was definitely a LinkedIn issue. So we are going to run it, but with slightly different format and with Guy at the helm. So that's what's happening next week. And then on the 28th, we've got a roundtable. We've got a succession planning roundtable with, I think there's about 5 of us on it. That's myself, Nigel Elks, Mike Ames, Richard Feekins, and I think it's Linda Underwood is our 5th one. So yeah, so it's going to be fabulous, really good. So if you're owner of business, thinking about what are you going to do with your business going forward, we've got a great roundtable to trigger lots of questions. But in the meantime, have a lovely weekend. Thank you very much, Richard. Thank you
My
for
pleasure.
tuning in, and cheerio for now.
Take care, all. Thanks, Nikki.